opportunity for us to host a really important conference. I want to really thank Rebecca Brown, our organizer, and someone who has had a few sleepless nights organizing this, but it's great to see you all here. And I want to thank the American Constitution Society and Lisa Brown, who brought this event to Vanderbilt, and I want to thank all of you for coming. I just will say a few words of introduction. My temptation was to say a few words about the importance of the Constitution. And the reason I was tempted is that as a dean, I spend a lot of time convincing people to do things they don't want to do, like give money to Vanderbilt or to teach a service course. And so I thought it would be refreshing for me to try to convince you of the importance of the Constitution. But I'll only say one thing, which is that when I was growing up, there was a voice coming out of the Supreme Court that spoke for the disadvantaged and the dispossessed. And it was an unusual voice because it wasn't a voice of anger, it wasn't a voice of victimization, but it was really a voice of entitlement. It was a voice which said what every human being, what every American is entitled to as a fellow citizen and a fellow human being. And I personally do miss that voice. And I hope one thing we can talk about here is getting that voice back again. That's not to say that I'm adverse to the countervailing voice of responsibility that seems to be, personal responsibility, that seems to be in the ascendancy these days. But I do think that responsibility begins with yourself, with us as members of a highly trained and well-paid elite. I know that because I set the salaries here. And our nation's leaders as extremely powerful people, as well as an elite, who have responsibility for the welfare of their fellow citizens. I do want to say a word about constitutional law here at Vanderbilt. We're engaged in a process here of really rethinking the legal curriculum for the 21st century. And constitutional law is a central part of that. You know, in a way that's interesting because the common law, first-year common law course represents modernity's one triumph over the Langdellian common law curriculum. It's the one course that is typically taught in the first year over Langdell's vociferous suggestions that it wasn't real law. So we do have that as representing something that at least reflects the 20th century. But what we're doing is really trying to think in educational terms about how we present this. Very often, first-year common law courses focus entirely on structure. And that's reasonable in a certain sense because you want to be, if you're going to cover one subject in depth, then you can't really obviously cover the whole Constitution. But one question that I've had, and that we're discussing here, is whether or not it really makes sense to cover one subject in depth. That is to say, the model of teaching each of our courses, first, second, and third year, at the same level of generality and the same level of detail, really makes sense. The Langdellian curriculum, in addition to being prior to the administrative state and internationalization and a whole bunch of other stuff, came prior to John Dewey and the whole notion of developmental education. That is to say that education is a developmental process. They thought it was a process of training the rational mind, like Plato and Aristotle did. But we now know a lot about education, and we know that it really is a developmental process. And the question we have is whether it makes sense to teach each course at the same level of generality, or whether we should, in the first year, present much more general kind of material that covers the entire range of American law, not just common law and the Constitution, but all the things that the students are going to see in practice and that they're going to study in depth in their second and third year. And this has led us to think about, at least, whether or not we could teach a broad introduction to the Constitution as in one semester of the first year, and thereby also signal to students that there is a Bill of Rights and that this is also important, rather than deferring this to the upper class and sending the message that the Constitution is largely a structural document. Now, there's some disadvantages to this. Obviously, this is material with a pretty high emotional valence. But on the other hand, one of the things John Dewey taught us is that you can't have enough motivation in education, and that engaging the students on an emotional level, something they care about, matters a great deal as well. We are then planning, we have a group of faculty working, to develop a really serious upper-class concentration in constitutional law and theory that will present students with a series of courses and then allow them in the third year to engage in a serious research project, perhaps a year-long course that's in a much more expanded format than the existing courses, and captures something else about the notion of developmental education. Namely, by the third year, they're ready to be something more than sitting a passive learning course. In any event, all of this is to say that constitutional law is very much on our minds. It's very much central to our educational enterprise here, and we hope that we're going to be able to generate a really rich discourse here about constitutional law. And so I want to welcome you as part of that discourse and a wonderful opportunity to talk and think about an extremely important subject as we move into the 21st century. Thanks all very much for coming.
You won't hear me if I also talk from here. Go to the mic. I want to welcome everybody on behalf of ACS and say a particular thank you to Dean Rubin for co-sponsoring this conference with us. We could not be more excited to be co-hosting this conference here at Vanderbilt. And personally, it's also just terrific to see all of you, a lot of old friends, some new friends, to talk about a topic that obviously impacts so many different areas of the law. And it's really I'm very excited about the discussions that are going to take place over the next couple of days. I also have I want to start by, I think many of you are aware that this conference comes out of a project, ACS project, the Constitution in the 21st Century, the goal of which is to bring together academics and practitioners to articulate a compelling progressive vision of the law and the Constitution on a wide variety of issues across the policy spectrum. The conference itself is specifically the work of our Constitutional Interpretation and Change Issue Group, which is one of 7 issue groups of the Constitution in the 21st Century project. And without its 3 co-chairs, we wouldn't be here today, and we wouldn't be about to have these fantastic discussions. And I have to start also by thanking Rebecca Brown as one of the co-chairs. This conference was her brainchild, as I'm sure most of you now know, from the earliest days of this issue group. And she has overseen everything from the highest levels of intellectual abstraction, what should the conference look like, what should its panels be, to the most mundane, guaranteeing that we're going to have really good food, including only she would think of having our favorite Girl Scout cookies this afternoon, apparently. But I know, having run our national convention for several years, exactly how much work goes into organizing a terrific conference like this. So we all owe her an tremendous a sense of appreciation and gratitude for doing it, so thank you. But also, no less influential on the conference has been Jack Balkin, who is another one of the co-chairs who's here. He has been instrumental in structuring the structure, the substance, and the voices that all of you are going to hear over the next couple of days, and really a lot of the content of the panels we have Jack to thank for. So Jack, thank you. And finally, Andy Pincus, who I'm not sure is here yet, who's the 3rd co-chair, who has his extremely smart but very practical perspective has made sure that we never, over the course of this conference, lose track of the fact that there are real-world impacts to the discussion that we're having. And in whether it's judicial decisions or policy discussions, the very intellectual debate that we're having has really important real-world consequences. I would also be remiss if I didn't thank in absentia Mira Trahan, who is in the National ACS office, who has been working on every piece of this conference. She would be here, except that she's due to give birth at any minute. And she really, if you all have not met her, you should and will. And I also want to make sure that everybody meets Judy Applebaum, who is the Director of Programs at ACS, and Liz Seaton, who is the Deputy Director of Programs at ACS. As you all know, originalism, original intent, original meaning have become very familiar words, not just to constitutional scholars and judges, but also to many average Americans. Yet the public discussion of originalism has been largely one-sided, and there's often been this sense that the results of an originalist interpretation are somehow preordained or cannot be questioned. Yet, as many of you know, in the academic world, there's been an awful lot of work done discussing originalism, debating it, questioning whether it really was the original intent of the framers, pointing out some of the inconsistencies in its interpretation, and actually wondering whether it really is even a method of interpretation that either even can or should be applied to changing circumstances. But this debate has largely, not entirely, Justice Breyer's book is obviously out there, has largely been confined to academia. You do not really hear it all that much in courtrooms, in legislative, you do sometimes, I don't mean to overstate this, but in courtrooms, legislative hearing rooms, or in the media. And so part of the goal of this conference is to start talking about this issue, think about how do we talk about it in ways that will resonate outside of the academy. And ACS's goal through this conference and through the ongoing work of the Constitutional Interpretation and Change Issue Group is to develop an affirmative constitutional vision that respects the text, structure, and history of the Constitution, but also makes clear that such respect does not mean relegating what I think is a really visionary founding document to a document that is somehow frozen in a particular period of time of several hundred years ago. This conference, as you can all tell, brings together some of the very best thinkers and writers about constitutional interpretation with a variety of different views to share and debate their ideas and to talk about how we can better communicate those ideas to lawyers, to judges, and to the public. We will publish a series of papers coming out of this conference, both short papers that we really want this conference not to just be about this weekend. We want it to have a continuing life. We hope that the publication will both serve as a resource for people and stimulate further discussion. So we will be talking to the speakers over the course of the weekend about working on papers because this is really to us an important aspect of the conference. So thank you for being here, and I want to turn things over to Christopher Yu, who is going to moderate the first panel this morning. He serves as the director of the program on technology and entertainment law here at Vanderbilt, but more relevantly to our program this weekend, he's one of the foremost scholars on the history of the executive branch and the power of the executive, and actually has a new book coming out on the subject of the history of presidential power and presidential control over the administration of law. So.
Right there. Hello?
Hi, Howard.
Thanks, Woolberry. Well, on behalf of Vanderbilt Law School, I'd like to add my welcome to everyone for joining us here today. It's an interesting format. I've done many conferences in this room, never one where I had the role of Johnny Carson. And I see by the microphone standing over there, I guess in the Q&A, I become Phil Donahue. So I mean, it'll be a very interesting experience for us. I'm delighted to have a role, to be able to have the privilege of moderating this panel, which is again looking at the historical roots of originalism. And traditionally, I mean, it's been looking at the modern debate and the fact that the relatively unreflective debate we've had to this point, as Lisa's pointed out, we would think that originalism is largely an artifact of the counter-majoritarian difficulty beginning in the late 60s with Alexander Bickel, and that in fact was really a construct, a modernist construct, largely popularized by the work of Robert Bork and Antonin Scalia. We have the privilege of having tremendous scholars with us today who delved into the history of the legacy of original intent and find out that in fact its legacy is much richer, deeper, and more complex, and that there's a much more interesting story to be told about there is, in fact, a historical foundation to originalism, but in fact that we moved away from it earlier in the 20th century and are now rediscovering it. And the journey that we've taken from moving away from this conception and coming back to us teaches us something powerful about the nature of American politics, the role that constitutional law plays within it, and in fact, it will teach us something very profound about the institutions we have today. The two scholars we have with us are perfectly suited to do this. The first speaker will be Howard Gilman, who's a professor of science and law at the University of Southern California, who's written extensively on the subject, and in fact, will lead off taking out the early history of original intent. He'll be followed by Barry Friedman, who is Jacob D. Fuchsberg Professor of Law at New York University, and more importantly, is my former colleague here on the Vanderbilt faculty. It's a pleasure to have both of them here today.
Great, thanks. So good morning, everyone. Barry and I are here to get the party started and set the stage, talk a little bit about the historical origins and debates about originalism and the living Constitution. We're going to be a tag team. In my 15 minutes, I'm going to cover the first 160, 170 years of the debate. And then Barry's going to do the next 30 or 40. I think that means that I have to talk 5 or 6 times as fast as Barry, so we'll see how that goes.
No easy task.
No easy task, that's exactly right. I think I'm here because almost 10 years ago I published a piece in a journal called Studies in American Political Development. It's not on Lexis, and so a lot of you have no reason to know that the journal exists. But in that journal, I tried to lay out an argument about the historical political origins of the debate between originalism and the idea of the living Constitution, really the political origins of the idea of the living Constitution. And in general, what I tried to do was suggest that this debate takes shape in the late 19th and early 20th century as industrialization triggers demands by progressives and other reformers to expand the power of the federal government in particular beyond the traditional understanding of those powers. And the way that this gets articulated is through the development of a tradition that becomes known as the tradition of the living Constitution. So the essay is about 21,000 words, and I was going to read all 21,000 words to you, but I think that instead all that I can do really is give you the gist. And so in a very broad brush, with very broad strokes, here's one reading of the history of this debate. So it would start as follows. From the time of the Constitution, I think, until the late 19th century, there was an overwhelming consensus that the appropriate methodology of constitutional interpretation was to be faithful to the original intent. And so it was assumed, as a result, that the meaning of the Constitution was fixed until it was amended. Now, actually, consensus isn't really the right word to describe this understanding in the early 19th century because there was really no argument about it. There was not a cottage industry of constitutional theorists arguing over the meta-theoretical question of what the appropriate interpretive posture is in the task of constitutional interpretation. That's a very modern phenomenon. There were simply disagreements about what the Constitution meant. Now, in order to prove this, you need a lot of close textual reading of a lot of documents. That's exactly what I don't have a chance to do now. But just to give you a flavor for what this kind of argument sounded like, a brief passage from Joseph Story's commentaries where he's talking about Marshall's decision in McCulloch versus Maryland, right? And so he says that the means by which the government pursues its enumerated and fixed objects must be subject to perpetual modification and change. The means must be adapted to the existing manners, habits, and institutions of society, which are never stationary, and so on. But he goes on to say at the same time, while the policy of one age may ill-suit the wishes or policy of another, the Constitution itself is not to be subject to such fluctuations. It is to have a fixed, uniform, permanent construction. It should be, so far as human infirmity will allow, not dependent on the passions or parties of particular times, but the same yesterday, today, and forever. And you get similar language in most of the constitutional theoretical discussions of this period. Just one other little quote. Thomas Cooley confidently writes at mid-century that the object of construction as applied to a written constitution is to give effect to the intent of the people in adopting it. A constitution is not to be made to mean one thing at one time and another at some subsequent time when the circumstance may have so changed as perhaps to make a different rule in the case seem desirable, because a principal share of the benefit expected from written constitutions would be lost if the rules they established were so flexible as to bend to circumstances or be modified by public opinion. Anyway, so there's just a lot of commentary like that. And it would make sense that up until the mid to late 19th century, this would be the sensibility. In large measure, one of the reasons why it was possible for people to have a consensus about that opinion at the time was that institutional arrangements and fundamental social economic relationships in the country, didn't change that much throughout most of the 19th century. There wasn't, if you will, the kind of dramatic social change that would lead people to rethink the continued relevance of the founders' world in understanding appropriate constitutional relationships in the mid-19th century. Okay, so what changes? Obviously, what changes in the late 19th century is that industrialization creates demands by progressives and other reformers. And the demands that industrialization create is a very specific demand, and this is, I think, a kind of central thing to keep in mind in understanding the origins of the living constitution tradition. With industrialization, what progressives and some other reformers wanted to do was expand the powers of the national government beyond the traditional understandings of those powers that had developed in the decades leading up to the late 19th century. That is to say, think of, for example, the unprecedented demands for federal regulation of production and manufacturing and agriculture with the Sherman Antitrust Act, for example. A role for the federal government in regulating the manufacturing of goods that really was not imagined before industrialization. These political exigencies, the desire for an American state that could cope with and manage the unprecedented social transformations caused by industrialization, those political exigencies created a demand for innovations in constitutional theorizing. That is to say, constitutional theory usually follows a sense of political urgency about rearticulating the meaning of the Constitution. That might, by the way, be why we're here today as well. That was certainly true of the late 19th century. So the result drew on aspects of the political, social culture of the late 19th century. It drew on traditions of Darwinism, American philosophical pragmatism, historicism, and all of those came together in the idea of the living Constitution, or the argument that interpretations of that document should change with new experiences and new social challenges. In particular, the idea was that this organism of the national government needed to grow. It needed to grow and become more powerful in relationship to its environment. And this meant rethinking the scope of the federal government's delegated powers. So, for example, Woodrow Wilson, before he became president, in his glory days as a political scientist, would explain that while the framers believed that politics was a variety of mechanics and that the Constitution displayed the laws of nature, we have since come to realize that society is a living organism and must obey the laws of life, not mechanics, and that government is not a machine but a living thing that is accountable to Darwin, not to Newton. And at some level, that metaphor, the change from Newtonian metaphors to Darwinian metaphors, is one of the most conspicuous features of the transformation in the way that people were talking about constitutionalism in the late 19th century. So this tradition begins to develop, and on my reading of the history, two distinct manifestations of this tradition take place in the early 20th century. It's expressed in two different ways that we're familiar with. The first is associated with Oliver Wendell Holmes, but then carries through to Frankfurter and other advocates of judicial restraint. And essentially, it argues for adaptation through judicial deference to legislatures. That is to say, it all but eliminates the idea of active judicial enforcement of traditional constitutional constraints against governing institutions. And here's the origin of the quip that the Constitution should be kept up to date, not by judges, but by deferring to the people's representatives. Think Lochner. Now, behind this idea are a lot of other ideas that we associate with Holmes's worldview. In part, it's the idea that it's inevitable that law and governing institutions will respond to the felt necessities of the time. There is a kind of cynicism about constitutional meaning. There's a belief in the inevitability of political power. There's an emergence of legal positivism. You know, there's a fatalism just about the whole constitutional project. Arguably, what you have is a kind of despair about the idea of continuing to maintain an earlier constitutional structure in light of big changes. In some respects, it's almost giving up on the notion that the Constitution maintains its full relevance, and except for, you know, very unique circumstances, we know that Holmes was extremely cynical and suspicious about the idea of a robust judicial enforcement of constitutional norms. In any case, one of the traditions that develops then is this idea of judicial restraint, refusing to impose these traditional guarantees, the inevitability of political power. But a second tradition also develops that probably is of greater inspiration to a lot of people who come today to the idea of the living Constitution. And here, this tradition starts not so much with Holmes, but with Zachariah Chafee and especially Louis Brandeis. And it's also carried on by Stone and other civil libertarians. And the notion here is that it's inconceivable that you would rethink the powers of the national government, that you would allow for an expansion of the powers of the state without simultaneously rethinking the protections of rights and liberties that are also embedded in the original constitutional document. And here is the origin of the tradition that we're familiar with, where an interpreter thinks of the Constitution's rights guarantees and liberty guarantees as stating abstract concepts or principles that could then be adapted to new circumstances and new threats to rights. And so here, for example, think Brandeis's dissent in Olmsted, arguing for the application of Fourth Amendment principles to the issue of wiretapping, where he writes that the Constitution must have a capacity for adaptation to a changing world, not just the clauses that empower the government to address innovative problems, but also those clauses, quote, guaranteeing to the individual protection against specific abuses of power. He says the Constitution may have been adopted to address certain evils, but its general language should not necessarily be confined to the form that that evil had therefore previously taken. Time works changes, brings into existence new conditions and purposes, therefore a principle must be vital. For a principle to be vital, it must be capable of wider application than the mischief which gave it birth. So as a result, then, what you have, that this living Constitution tradition takes the form essentially of what throughout the 20th century becomes a kind of an ethic of judicial restraint on the one hand, which ties back to Holmes, and an ethic of a more active, imaginative judicial protection for civil rights and liberties, which I tie back to Brandeis and some of these earlier folks. So then what happens? Well, the New Deal battle, then, is expressly fought between the old guard conservative originalists, and that's how they articulate their defense of the old order, what their critics would characterize as the old horse and buggy constitutionalists, right, as a way of delegitimizing a notion that constitutional meaning is fixed in the late 18th, early 19th century. And the progressive advocates for a theory of the living Constitution, for adapting the Constitution to the extraordinary new circumstances brought on by industrialization and the Great Depression. And the major, actually, public defender of this new theory of the living Constitution is Corwin, as a spokesperson going on the radio and really advocating for this. So, for example, in response to Sutherland's dissent in Blaisdell, where he really insists that, if the Constitution means anything, it has to mean that you can't have debtor relief legislation, the meaning of the Constitution doesn't change, and so on. Corwin writes that the Constitution's founders could never have had an intention as to something, social conditions of 1933 to wit, which they could not have imagined or foreseen. That the Constitution must mean different things at different times if it is to mean what is sensible, applicable, and feasible. The first requirement of the Constitution to a progressive society is that it keep pace with that society. And the political defeat of the conservatives during the New Deal battle is the beginning of the dominance of the living Constitution tradition for the next few decades, and the eclipse of the original idea of originalism in most of our constitutional discourse. That is to say, Sutherland and his gang represented what folks like Randy Barnett right now refer to as the lost Constitution, a robust original document that imposed limits based on the limited delegated nature of its authority and so on. But that tradition goes into eclipse mostly in the 40s, 50s, and 60s. And for a while there is no debate between originalists and the living Constitution types. One reason why the debate is quieted in the 40s, 50s, and 60s is that there's a broad consensus among judges anyway about the scope of federal power. That is to say, FDR and the New Dealers reconfigured the federal judiciary so that there weren't Sutherlands and others continuing to defend the old order. So the idea that federal power had to expand in light of new circumstances was a political consensus forged after the New Deal. And because there wasn't a robust civil liberties tradition on the court in the 40s, 50s, and 60s, that you began to get a footnote 4 sensibility, a preferred freedoms tradition slowly emerges, but Truman takes care of that after Murphy and Rutledge retire from the court to ensure that the court will be a relatively tame court on the issues of rights and liberties. So I'm almost getting to the point to hand the ball over to Barry, but just as a preview of coming attractions, my sense of what happens after that is this, that the modern debate over originalism and the living Constitution gets reignited by Warren Court innovations in the interpretation of the religion clauses, due process, and privacy, really drawing on this kind of Brandeis Stone tradition. The conservative critique of this tradition is often articulated in originalist terms, right? That the framers would have never envisioned, these particular understandings of due process. There is no right to privacy in the Constitution and so on. But what I would want to emphasize about that first wave of modern originalism is that it actually drew more on the Holmes and Frankfurter tradition of judicial restraint. That is to say, the argument was an argument of stingy originalism about rights, but not an originalism of delegated powers, right? I mean, it was simply an argument that judges should defer to the elected branches. And so while it looks like the first wave of modern debates about originalism take the form of an originalist argument, they're actually a version of the living Constitution tradition that gets created in the early 20th century by Holmes and Frankfurter, who are not originalists, I think we can say with some confidence. What is necessary for the second wave of modern originalism, the new originalism to happen, that is to say, for a kind of neo-Sutherland view of originalism to reemerge, what's necessary for that to reemerge are two political conditions. One is that you need to reinsert in the political system an argument about the legitimacy of the New Deal. Right? That is to say, you need to shake up the consensus that the New Deal expansion of federal power was inevitable and appropriate. And you need to create a federal judiciary that can be trusted with a kind of neo-Sutherland originalism about delegated powers. And so for the new originalism to emerge, what you need is the Reagan Revolution and the Gingrich Revolution in the early 90s, which simultaneously calls into question the New Deal, the legitimacy of the New Deal, that it's, the New Deal itself represents an assault on the original Constitution and an expansion of federal power beyond that which the framers would have acknowledged, and which reconfigures the federal judiciary such that you can give these federal judges not simply the charge of deferring, the kind of Holmes and Frankfurter legacy, but the Sutherland legacy of imposing traditional restraints on the new federal government. And that's why we see in the 80s and especially the 90s, the new originalism emerge, because as we know, constitutional theorizing follows the felt political necessities of the time. But since that happened, there have been a lot of arguments about how that debate's unfolded, and that's what Barry's going to talk about.
So thank you, Howard. We really are going to be a seamless web, and as is uncommon often in the Academy, we agree about most of this. So I agree about virtually everything that Howard had to say. Must be true. But there's two things I think I want to emphasize before I move on. The first is, because he's a good scholar, I'm willing to take Howard's view that there was a consensus throughout the 19th century that originalism was the appropriate way to interpret the Constitution at his word. Though I feel like if I really wanted to know that, I'd have to go read all the cases and see whether the judges really adhered to that, or whether they did other things as judges commonly do. But it is worth noting, at any rate, that throughout the entire 19th century, there was fundamental disagreement in the country about the very most basic of questions concerning the Constitution, about the nature of the federal structure. And so right away you have a tip-off that originalism is the methodology. You've got a problem here because it isn't getting you an answer to the question that you need to have answered. The other point I want to highlight, and this is a theme for the remarks that I'm going to make that follow, and this echoes something that Lisa Brown said right at the beginning, is we live in this little bubble. You know, there are several hundred of us who are legal academics and political science academics and historians who talk to one another about this. And we can make the bubble bigger and include some Supreme Court justices and some judges and maybe some other folks. But we shouldn't confuse our little bubble with the public at large, because it's a different world out there. And a lot might be able to happen within the bubble. I think that's something that we should talk about. But sooner or later, if you've got a constitutional agenda and you've got an interpretive methodology, you're going to have to persuade the public that that's the right way that things should happen. And so I think we ought to focus on what it takes to persuade the public. Now, a whirlwind is coming, so you might want to buckle on your seatbelts. But I'm going to give you foreshadowing of what it is that I hope to persuade you of by the end. So the first thing I want to argue, I have a suspicion that many of these are going to be quite controversial, is that originalism has never won a public fight. The second is that living constitutionalism has never lost one. And the third, and I'll quote Leonard Levy when he was writing about the Nixon court's criminal procedure decisions in '74, he says, "The public cares about results and has little patience for reasons." Or if you want an interesting authority on that same subject, Robert Bork, "Any theory worthy of consideration must state both an acceptable range of judicial results, and in doing that confine the judge's power over us." Not sure the second part works, but the first part is instructive. So one of the points I'm going to make again at the end is, if we're here searching for an interpretive vocabulary, that might be putting the cart before the horse, that what you've got to sell to the public is a constitutional or otherwise agenda, and then the language follows from that. And it's the agenda that really ought to matter and not the language. Okay, so history. I agree with Howard about everything that sort of came first. And after the New Deal, people often say that there was this return to the Constitution. They abandoned the living Constitution to go back to Marshall. I'm not sure if you read decisions from the 1940s, the flag salute cases or Korematsu or any of the Wickard versus Filburn, that that's actually what's happening, but no matter. By the time we get to the Warren Court, transformative social and constitutional change is happening in the area of race relations, criminal procedure, school prayer, reapportionment, the First Amendment. We all know the story. And one of the problems, as Howard points out, but I actually think it gets more acute later, is some of that, at any rate, is tough to tie to our notion of what was the original Constitution. So one result of the Warren Court is that there's a backlash. And in 1968, Richard Nixon runs against the court, largely in response to the criminal decisions, and he wins. And when he wins, Nixon promises the country, and this is a very public event, that he's going to appoint strict constructionists, people who will not twist or bend the Constitution in order to perpetuate his personal, political, or social views. So we have an interpretive promise. And he gets 4 appointments: Berger, Blackmun, Powell, and Rehnquist, not flaming liberals. By the way, Stevens gets 4. The Democrats don't get much in the way of Supreme Court justices in this period. And they all take the pledge. So here's Blackmun taking the pledge. In their confirmation hearings, they take the pledge. "I personally feel that the Constitution is a document of specified words and construction. I would do my best not to have my decision affected by my personal ideals and philosophy, but would attempt to construe that document in the light of what I feel is its definite and determined meaning." So we get these appointments, we get this promise for strict constructionists, we take the pledge, and what do we get? In Furman, we overrule the death penalty. We, in the gender equality cases, Frontiero and Reed versus Reed and Craig versus Boren, we find that there's gender equality in the 14th Amendment, despite noticeably the failure of the country to ratify the Equal Protection Amendment. And most importantly, we get the abortion decisions. And there's a feature to all of this stuff, which is it's really hard to explain where it is in the original Constitution. So, you know, we don't have to have conservatives worrying about that. Here's Ruth Bader Ginsburg talking to a Ford Foundation audience when she's a litigator. It's very clear that the framers of the 14th Amendment did not have women in mind. And here's one of my favorites. This is Linda Greenhouse when she's a cub reporter in 1970 covering some abortion trials in New York. She says, I wish I could sort of do an impersonation of Linda, but a right to abortion, such a notion, at first hearing sounds fantastic, illusory. The Constitution is searched in vain for any mention of it. The very phrase rings with the rhetoric of a women's liberation meeting. So these decisions come down, and there's a hullabaloo, and the hullabaloo comes not from the right, but initially from the left, abortion being the most controversial of decisions. And I'll remind you of what you already know. This is John Hart Ely talking about Roe versus Wade. He says the Constitution simply, I mean, these are damning words, simply says nothing clear or fuzzy about abortion, a charge that responsibly can be leveled at no other decision in the past 20 years. It is not constitutional law, and it gives almost no sense of an obligation to try to be. So this is a problem that the left has and the left needs to respond to. And they do, but their reaction is kind of bizarre. I mean, maybe it didn't seem that way at the time. I'm sure it didn't. These are all smart people, but looking back, it seems a little bizarre to me. And it's captured by a lawyer who's sympathetic to all this. He publishes an article in the Texas Law Review that's titled, Abandoning the Constitution, the New Wave in Constitutional Theory. And that's exactly what happened. So in important articles that you all know by Tom Gray and Paul Brest, by Michael Perry, Ronald Dworkin, the articles, and particularly Gray's and Brest's, have a core point that is just irrefutable and undeniably sensible to them, which is you cannot take the status of constitutional law as it exists now and square it up with this original Constitution. You can't apply an originalist methodology and explain the post-New Deal regulatory authority, Brown versus Board of Education, perhaps, Bowling versus Sharp, selective incorporation. You can't get there from here or here from there. But where they go from there is to say, so we'll just let go of the Constitution, mostly in favor of, I guess, moral philosophy. So here's Brest. This is what Brest thinks judges should do. And again, because we're talking about the public, I want all of you to think about selling this to the public as a theory. Judges should ask, how well, compared to possible alternatives, does the practice contribute to the well-being of our society, or more narrowly, to the ends of constitutional government? Or here's Ronald Dworkin, early Dworkin, by the way, because by law's empire, he's got the game entirely, and it's law's integrity and no activism. We're going to be faithful interpreters. But this is early Dworkin, and taking rights seriously. He refers to the vague constitutional provisions, and he says the court, this is remarkable to hear somebody saying this, the court must be an activist court in the sense that it must be prepared to frame and answer questions of political morality. Well, this is not a shock that this is going to get people in trouble. And so it does. So here's the reaction. This is Gary McDowell, who's a conservative constitutional theorist and is going to play an important role in the Meese White House. He says, the question today is not so much how to read the Constitution as whether to read the Constitution. Ed Meese, when he goes into the public eye on all this, referring to the left scholars who are constantly set up and dealt with that way, he says, constitutional adjudication is not primarily a matter of construction at all. They appear to view the United States Constitution as a document virtually without significant meaning. Now, the right's got a problem. I'm going to talk about that in just a moment, but I want to take a tiny detour to say there was an alternative. And the alternative was living constitutionalism. And when I say that was an alternative, what I mean is that if you look at the words of countless people in this period, the idea of the living Constitution and interpreting the living Constitution just rolls like a tick off of their tongues. So here's Pauli Murray and Mary Eastwood, who were important figures in the 14th Amendment ERA debates and wrote an important article. They say, the genius of the American Constitution is in its capacity, through judicial interpretation, for growth and adaptation to changing conditions and human values. Here's the court in Harper, the poll tax case. We have never been confined to historic notions of equality. Notions of what constitute equal treatment for purposes of the Equal Protection Clause do change. Here's Blackmun struggling, this is in Linda Greenhouse's book, struggling over Reed v. Reed and what to do with Reed v. Reed, he says he recognizes that the 14th Amendment was not intended to meet any sex differentiation when it was adopted 100 years ago. Nonetheless, my own feeling is that these constitutional provisions must have some flexibility and expansiveness in them, as in theory we ourselves progress and expand our concepts of equality. And finally, Lewis Powell, when he retires, he says, I've been alive 80 of the 200 years of the Constitution. This country is very young. How can you say the Constitution should be frozen in time, that it is not a living document that must be interpreted? I mean, people just say this over and over and over, and they say it. I mean, this is sort of a message of mine, because when they look at the world that they're in and what the Constitution needs to do, it just makes sense to them. So I'm going to flash forward over a fascinating political story that I've spent the summer worrying over, which is the mobilization of the right and the rise of the religious right. Figures like Phyllis Schlafly and Paul Weyrich of the Free Congress Foundation and Richard Viguerie, the direct mail guy. But what happens is, in 1980, Reagan is elected with their help, and they've got an agenda, and they're very aggressive about judicial selection and getting their guys on the bench. But they need a vocabulary. They need a vocabulary that matches the agenda that they already have. So one of the really important things about their agenda is, if you want to have a constitutional agenda and you're writing on a clean slate, that's easy. But if you've got this accretion of all these precedents with which you don't agree, you have a problem. You've got to get around stare decisis. And so, one of the ways around stare decisis is, as Robert Bork tells us, an originalist judge would have no problem whatever in overruling a non-originalist precedent, because that precedent, by the very basis of his judicial philosophy, has no legitimacy. So originalism is a precedent breaker. It's how Justice Black used it in the 1960s, and it's how the conservatives use it now. That's its purpose. The other purpose, by the way, is it pairs up nicely with democratic legitimacy. And if you have any historic sensibilities, you find it peculiar that conservatives are worrying about democratic legitimacy as opposed to constitutionalism. But you must remember they win a couple of big elections in the 1980s. So all of a sudden, democracy looks a lot better. So, where do you get this vocabulary? Well, there are all these conservative foundations and think tanks, and I give huge credit to the Federalist Society for coming up with the vocabulary. Now, lest you think I am a fool, I am not going to argue to you that the Federalist Society thought up originalism. I'm perfectly well aware. I mean, I heard Howard's talk. I agree with it. I know Justice Black did it. I know Raoul Berger made it a cottage industry, a genre perhaps. But we ought not to be naive about the fact that conservative thinkers took a concept off the shelf and tailored and sculpted it to meet their needs. And again, I make, there's no sort of hypocritical instrumentalism in this. If you've got an agenda, you need to see the world in a way that makes sense to your agenda, and this one did. But so in 1985, as you all know, Mies takes the stump, advocating a jurisprudence of original intention. But in 2 years, that jurisprudence of original intention morphs into a whole new thing, a jurisprudence of original understanding. It's been tailored and shaped to meet the objections to it and to get it to do what it needs to do. And in 1987, the Office of Legal Policy publishes an original understanding source book that explains how it's changed and what it, well, it doesn't explain that it changed. It sells itself as being an inexorable truth, but what it is, what the doctrine is. However, we get some folks associated with the Federalist Society who, are kind of bragging about what a job they did tailoring this theory. So this is Steve Markman, who was the founder of the D.C. chapter of the Federalist Society, and he was on the Hill as a staffer, and then he comes to OLP to run judicial selection. And Markman talks about how the society helped refine Mies's original nomenclature, quote, in a very useful way to original meaning jurisprudence. And he's enthusiastic about our debate to try to render more sophisticated what it is we are talking about. And this is Gene Meyer, the executive director of the Federalist Society, talking about how these discussions and debates led not all but most conservatives to abandon original intent and adopt original meaning. And my point is, if you're selling something as the one truth in an inexorable and long-standing way to interpret the Constitution, you don't need to have skull sessions to figure out what the theory is, right? They're clearly shaping the theory to meet what they need it to do. Now, we could talk about how determinate that theory is. It obviously has its problems, but where I want to go now is, it doesn't happen often in the world, but we actually get to have a fight about this. So in 1987, Lewis Powell resigns from the court, and he's the swing vote. a 5-4 court on lots of issues that matter to social conservatives: affirmative action, the death penalty, abortion. Time magazine says, all at once, the political passions of 3 decades seem to converge on a single empty chair. And Ronald Reagan, the conservative dream, he nominates Robert Bork. And you should hear the conservatives before the White House got them under control and told them to be quiet. So Jerry Falwell says, we are standing at the edge of history. And Don Pompeo at the Washington Legal Foundation, and this quote's going to sound familiar because you're about to hear it coming out of liberal mouths all the time, we have the opportunity now to roll back 30 years of social and political activism by the Supreme Court. Bruce Fein at Heritage Foundation says the same thing, and everybody agrees the fight's going to be about philosophy, not about scandals, not about whether you were hearing cases in which you had financial interests. We're going to go to the dirt on the thing that matters, philosophy. Now, not exactly. It gets shaped up by the sides. So the White House makes a decision that the one thing it doesn't want to do is have a fight about the hot-button issues for conservatives: abortion, gay rights. They're not going there. This is Howard Baker's poster and contra White House. And so they decide that they're going to sell Bork based on his outstanding credentials and his interpretive methodology, originalism and restraint. The left, they don't want to have anything to do with abortion either because their polling's told them that that's a terrible idea. So they're going to oppose Bork for rolling back the clock on civil rights and for privacy. And Griswold's a fascinating case that we probably could talk at great length about. And there's the summer, the left mobilizes, there's a huge campaign. But at the beginning of the hearings, the country, if it's tuned in at all, is kind of a split 50-50 on Bork. And then Bork takes the witness stand for 5 unbelievable days in which he completely shoots himself in the foot. And at the end of that time, it's basically over. And if you want a political explanation, and perhaps it's important and we can come back to it, it's largely over because all of the Southern Democrat senators decide they're not supporting the nomination because their black constituents are going to be livid if they do. And as best as they can tell, the conservatives and the white constituents just don't care that much. But what does the Bork fight mean ultimately? Well, Nina Totenberg at NPR says, and remember, we've shaped this up now as a fight about results versus interpretive methodology. And Nina Totenberg says, the public seemed to support most of the court's decisions in the areas of race and sex discrimination, free speech, privacy, and even abortion. And Ethan Bronner at the Boston Globe, who had a catbird seat, wrote a wonderful book on the Bork nomination, very sympathetic to Bork in many ways, but he's unequivocal about what happened. He says that Bork had argued that over the last generation, the court had stretched the national charter beyond its capacities, stitching together new rights with random bits of constitutional cloth. The results of his nomination indicated that most Americans disagreed. Now, you could say these are the left-leaning journalists, and so we shouldn't take their word for it because we know we can't trust the left. But so here are the conservatives talking about the same thing. Now, the conservative interest is not to agree that it was fought on philosophy, but to say it was a smear of Bork or the beer didn't sell or whatever have you. But in their candid moments, they're quite clear about what happened. There's a wonderful book by Patrick McGuigan, who is a right activist working hard for the Bork nominations, angst-ridden book. And he says the left frequently lied in their advertising, but still, they largely understood what it was his nomination meant for the liberal jurisprudence and politics which dominated America. Bork was borked, he says, not because he was misperceived by his opponents, but because he was correctly perceived. And it's interesting to listen to Anthony Kennedy take the witness stand in his confirmation hearings. Here's a different man. He talks about a spacious concept of liberty. He says he has no overarching theory of interpreting the Constitution. And then he says, this is his version of originalism. It sounds a lot like living constitutionalism. I think 200 years of history gives us a magnificent perspective on what the framers did intend. Actually, I want to wrap up, but I forgot one quote I just have to read you from Hal Heflin because this is remarkable. This is Hal Heflin explaining how he gets the decision to vote against Bork. Watch mixing metaphors here. He's got deep concern as to whether this nominee would be a conservative justice who would safeguard the living Constitution and prevent judicial activism, so you've got to work hard to get there, or would be an extremist who would use his position on the court to advance a far-right radical judicial agenda. When in doubt, don't, he said. Okay, so I'm going to sum up. I don't think originalism's ever won a public fight. Now, it may do a lot under the radar screen, and we should talk about that, but that's the important point. Living constitutionalism's never lost one. I haven't done the research I want to do, but I lived through the Roberts and Alito nominations, and it's my impression that originalism is not what was sold. What was sold was the rule of law and stare decisis. We also ought to talk about what a model of constitutional interpretation should be. I just want to lobby for one of my personal favorites, Justice Harlan, who was strongly of the view that decisions that accord with the history and traditions of the American people survive, and those that don't, don't. But most important, I guess I want to urge us all to not fixate on vocabulary. You know, what matters in the end is selling an agenda, constitutional or otherwise, to the American people. And when you've got an agenda, the vocabulary follows because it's what makes sense of the agenda that you have. And at least sitting here at the Coffee Klatch, my impression is that the right has a pretty clear idea of what their agenda is, and the left hardly does. And that, in fact, may be the deeper problem.
One of the mandates here is to leave a lot of time open for questions and to make sure all this is recorded wonderfully for those of us who are viewing on tape. If you would, I'll come around and help you with this. Anyone have any questions for the panelists? Can you identify yourself, Judge Merritt? But all questioners, just so everyone can get to know each other better.
Barry, in the bubble that you refer to, what's your guess as to, in the academic community, how many of the people who are interested in this subject and live with this subject and write on this subject and teach this subject are originalists?
There was a joke that went around when Reagan started putting conservative academics on the court that he'd done more to make the academy liberal than anybody had in a long time. I mean, I don't think that there's a lot of originalism that goes on, though there's a lot of talk about originalism. So there's, ever since the Bork nomination, it's still going on. I mean, Peter Smith and Caleb Nelson have published recent articles. There's lots of conversation about originalism, both trying to refine it and, attacking it. How much of the scholarship is about, with a nod to Jack Balkin's recent piece on abortion, is an attempt to develop an original interpretation of the Constitution? I think there's a fairly small amount. But I also don't know, and with all deference to Jack, that that's the right strategy, certainly on the left.
It seems as though there was a time in the early 70s when sort of constitutional theorists on the left played with the idea of kind of abandoning a commitment to originalism and just embracing a notion of adaptability based on improved sensibilities about rights and the like. But I'm not sure. I think that seemed to be a false start. And it's hard to find somebody right now who doesn't at some level gesture toward a strong notion of fidelity, right? And so the idea that we're going to start using the language of non-interpretivism for a while, and if we weren't going to interpret, then you have to articulate, well, what are you doing if you're not interpreting? That idea, I think, became a false start. And what you're seeing now, I think, are competing conceptions of originalism, right? Which I guess you might call traditional originalism and progressive originalism. Dworkin is an originalist. Jack is now an originalist. And, there are these intramural debates about, well, whether what was in the mind of the framers constitutes, the authoritative source, or whether you could have original meaning but not original expected application, or original concepts but not original conceptions. I mean, we're trying to figure out what that language is, but I think that, the traditional kind of Corwin debate between the horse and buggy originalists and the people committed to adaptation in light of new circumstances, that strong division between these traditions, which is how I think it was initially articulated in the early 20th century, I think has reached a kind of equilibrium. And I'm not sure that the left any longer talks about the idea of fidelity in a way that is somehow not tied to some notion of what the original text is about. Although I think there are still lots of arguments about how you conceptualize what it is about the original text that you're being faithful to.
I couldn't disagree more with that, and I think it's important to say. And maybe it's just your use of the word originalism. I think the public always demanded, and that was the wrong move in the 70s, that we be interpreting the Constitution.
Right. That's
right. I mean, we're never going to solve the judges' values, getting their own values in. I mean, that's just a fool's game, and we all can point fingers at each other about where there's indeterminacy. The public does want to know, though, that it's a constitution. But I think to fall into the originalist trap is a big mistake. One of the strongest things that sort of a left jurisprudence has going for it, I mean, that was the tick I was talking about, was all these people think it's got to be that women are equal, and we all know that isn't what they meant in the Constitution. So the Constitution has to adapt and grow and change. And what is needed is a way to capture that change, because that's actually the right's biggest vulnerability is, and you know, they do some strange stuff to explain why the original Constitution gets them the results in cases that, you know, are sacrosanct now. And so the task, I agree, it's got to be constitutionalism. I mean, not getting the Constitution out of constitutionalism was a big mistake.
Right.
But I don't think it has to be originalism. And I think ultimately, in a public fight, something called originalism that's just about doing what they thought we were supposed to do 200 or 100 years ago is not going to win.
That's exactly right.
Sorry, I'm Frank Michaelman. This is just a comment on what we've just heard among Judge Merritt and our two speakers. Isn't the message that's coming forward something like the search is on for a notion or notions of fidelity to the Constitution that are not necessarily originalist notions? That is not necessarily originalist either in the sense that they're fixated on framers or in the sense that they're fixated on clauses or on texts. That is, Barry's living Constitution is meant to be the object of fidelity. It's what fidelity will be faithful to. So somehow or other, what one needs to do is construct a plausible or better than plausible conception of what this object of constitutional fidelity could be, other than you know, a collection of clauses, a collection of texts, and other than the understandings, intentions, and designs of people who did their work 200 or 190 or whatever it is years ago. So, but the point is, fidelity and originalism are being pried apart here, because I think the one point that's clear is we can't take leave of fidelity. Probably very few people would be comfortable about doing that, and it's not what our public wants or would be comfortable with. So just a comment.
Yeah, I mean, I think, you know, it's interesting. We're living in this world where there's this polarization from the political extremes. And, you know, studies show, and my sense is, that the middle of the country isn't discontent. It's certainly about the Constitution. I mean, Fred Schauer's forward this year is going to be a wonderful exercise in pointing out that all these hot-button social constitutional issues are the last thing on the public's mind. They care a lot more about the war and the economy and gas prices. And you know, we've had some median justices on the court now for a while, O'Connor and Kennedy, who've pretty much stuck the doctrine where a lot of people in this country are willing to live with it. And that's why we hear a lot about stare decisis when, I mean, whether they deliver or not, when Roberts and Alito are testifying, because the public doesn't want a lot of change, I don't think. And so I agree with everything you just said, Frank. And it seems to me that what you want to persuade people love the Constitution, and what you want to persuade them of is that this is a Constitution that fundamentally reflects who we are and have been as a people over a long period of time. And that's what we ought to be looking at. Shameless plug, I published an article called The Sedimentary Constitution that said that a while ago, but I still think it's true.
Highly recommended. And I do think that that reframing is a good way to think about it. It is, after all, the cover of the brochure of the conference, right, that you're speaking of in terms of maintaining fidelity. What's interesting about, for example, Brandeis's move into Olmsted and some other decisions was that he thought that continued fidelity in light of changing circumstances required kind of an updating of thinking about how the Constitution applied, because he thought that the alternative to that was that the Constitution would become irrelevant, right? And so that if you, from his point of view, if you want the Constitution to maintain its relevance in light of changing circumstances, you need a conception of fidelity that, wherein, you know, it speaks in a language that can address, you know, conditions that the framers couldn't have imagined. You know, otherwise, you know, there's a radical disconnect between the Constitution and, you know, the lived experience of our existing polity. And but figuring out how the language in which that gets articulated, I think, has been, you know, has obviously been the challenge, you know, since Brandeis gave it a shot.
Bill Marshall, UNC. This I think is repetitive of where the comments just were, but what we're beginning to see is originalism really formed two functions. One was an argument to try to constrain where they thought the court was going. It was an argument on illegitimacy. And this constraining notion is what we're talking about here, that you need an interpretive theory that suggests that there is some constraint. The second function, and I agree with Barry, it would never accomplish it on its own, this notion of originalism as providing the actual rules of decisions in cases. But this first part is still a powerful critique that the originalist argument offers, which is that if you don't have originalism, you do not have any real constraints on the exercise of judicial power. And my question is, does the answer, we have a living Constitution, in any meaningful way answer that political concern, or does it just sound too malleable?
That's the hardest question, I think. And, you know, this is the constant refrain that the judges are, I mean, that's the pledge, right? I'm not going to impose my, I love Harry Blackman taking that pledge. And it's very hard to know what the answer is. I mean, we don't think that originalism does it, right? That's fanciful. For 100 years, they couldn't agree on what the federal structure of the country was. It seems like they'd have hammered that out at the very beginning, and they obviously didn't. And, you know, you watch the conniption fits over Brown versus Board of Education, and you realize there's a real problem there because there are these icons in the law that originalism's got to meet. But I want to just concede, I mean, I don't think finding the vocabulary here is very difficult, and I do think that the agenda is the tough issue. I think a far more interesting strategic question, and I don't have an answer at this point, is how do you meet the objection that any methodology you have constrains judges? Because people do seem to like to hear that it's law and not just, they may know that it's who it happens to be, but they like to know that it's law.
Yeah, and I think that first of all, from a kind of social science perspective, which is probably the least relevant perspective that we're talking about, I think the evidence is overwhelming that merely articulating a commitment to a notion of originalism has no effect, no constraining effect on judges whatsoever, right? So the evidence on that is pretty clear. Whether that argument translates into a public argument, I mean, the public does want to sense that judges are not free-floating, you know, advocates. But I think the idea of fidelity, you know, gets you a lot of the way there, and you begin to say, listen, you know, you want a sense of fidelity, but originalism doesn't get you that fidelity for a variety of reasons we could talk about. But the other important thing is that today, the idea of originalism was about imposing restraints on judges. I mean, at least in the public argument, you know, that's the urgency of, you know, why we need to take the argument seriously. It's important to keep in mind that's not the argument, for example, in the late 19th, early 20th century, right? I mean, that argument for originalism was about constraining not judges, but constraining federal power. That's right. And so, and you know, it might be that with the new originalism, that's what's seen as the main benefit of this kind of second wave of modern originalism, is that it's a resuscitating a kind of pre-New Deal conception of how you understand the scope of federal power.
I mean, I like Harlan, and I like consistent with the history and traditions of the American people, who we are as a people. And, you know, you can ask the question rhetorically, which is to say, well, you want to limit judges. I mean, do you want to limit them to what's consistent with who we are as a nation and our history and traditions, or do you want to limit them to what they thought 200 years ago when, you know, equality didn't extend to women and it didn't extend to African? I mean, I think originalism has a sore point there. I don't know that you can sell it history and traditions as determinate, but that's the sell I'd like to try to do.
I'm Robin West. Thank you for your comments. I guess I too want to focus on this word fidelity and think of it as a virtue and think of what the case for it might be. So let me introduce this sort of fanciful analogy. We also talk about fidelity to one's spouse and fidelity to a marriage, fidelity to the institution of marriage. Well, fidelity to marriage presumably doesn't mean serial monogamy, right? It does. I mean, someone who's all for marriage, you don't think of that person as the person who gets 6 divorces over an adult lifetime. They're loyal to the institution, but not to any particular individual. Okay, but on the other hand, a spouse is a human being whose cellular structure over an adult lifetime undergoes a 100% turnover, okay? So fidelity to one's spouse doesn't mean fidelity to the 18-year-old you married either, okay? So fidelity to one's marriage doesn't mean either that you just love the institution of marriage, so you're going to do it a whole bunch of times, but nor does it mean fidelity to the original person who was your bride or groom on the day of your wedding, right? That's ridiculous. Okay, well, likewise here, I think it's easy to say fidelity to the Constitution can't mean fidelity to any old constitutional vision that pops up from year to year, but nor can it mean fidelity to the original thing without without risking being really silly, or as you all say irrelevant, or just a non-winning package to the American public. But that does then leave this question, because sometimes there is a very strong case for divorce, and indeed there may be a pretty strong case to be made against the institution of marriage. And so what I'm trying to say is that the positive case for fidelity to a living constitution, to a non-originalist constitution, whatever you want to call it, isn't obvious. It's not just clear. You need to make fidelity is a virtue. And I would also urge that the case for fidelity as a virtue needs to be made independent of questions about the role of judges. There is this prior question of why you'd want to constrain a well-functioning democracy with the traditions of the American people. I'm not saying they don't want to do that, but why would you? There's a gap here that I think needs to be filled, and I really hope we make some progress over the next 2 days in filling that gap.
But there's a chicken and egg problem, right? I mean, that is to say, before you know whether you want to be faithful to the Constitution, you need to figure out what is it that you're trying to be faithful to. That's right. So there's an identity question which precedes the fidelity question, the normative fidelity question. And so it may very well be, right, that if you conclude that the Constitution, properly interpreted, leads to all sorts of crummy results, and from your point of view, to hell with it, right? I mean, it's better actually just to formally say, that we should not be faithful to that document. We should articulate an agenda for a new Constitution, because as long as we're stuck with this document, it's not going to get us where we want to be. And it's a very interesting question for progressives, right? I mean, if you were convinced that the original document, is inevitably going to be viewed as not sufficiently attentive to social inequality or women's rights or civil rights and a variety of other issues, then, right, to hell with it. But before you get to that point, you need to have a decision about what the right interpretive frame is. And so
the article I wrote was about this, why it is that we're faithful to this history and tradition. And it's basically an argument that history is accretive, that over time we become who we are. We sort of get fixed in stone, and it's impossible to drill back to the beginning, that you just shape who you are for reasons you might like and reasons you might not like. Divorce is hard to sell as a theory of constitutional interpretation, but it does lead me to just one thing I thought to say at some point during the course of these next 2 days, which is an interesting question we ought to ask ourselves, which is whether the left agenda is a constitutional agenda or a non-constitutional agenda. So if you try to figure out what it is that the right cares about or ought to be for, what the country ought to care about or be for, it's hard to know what that is, but it might involve a lot of economic issues that are really hard to place into the Constitution that we have right now. Now, it could be, and in fact, this is sort of my view of how the world works, that at the time that the country's ripe to do those things, we'll figure out why they're in the Constitution. Frank obviously said a lot of this a long time ago. But so, it just may be that the left's agenda isn't a constitutional issue in some ways that the right's may seem to be.
We've unfortunately reached the end of our time, with apologies to those of you who still have questions left. We have a wonderful panel setting up the rest of the conference. The issues of fidelity will be discussed at the next panel at 10:45. And more to the point, what's really striking to me is about the themes that both Barry and Howard set, is a question of possibly how does constitutional theorizing figure into progressive change. In fact, they both lay out a vision in which theory and vocabulary follows change instead of leading it. And it raises the profound question asking this conference is, what is the role that conferences like this play? And if so, constructively, what can we do? That's a wonderful topic, which I think we'll all enjoy talking for the next day and a half. And the next panel will start at 10:45. A pleasure.